Pleased to be here. Thank you, Your Honors, for this privilege actually to talk to you about this important case. I'm going to start with a short paragraph written by none other than the DHS. The DHS, by and through undersigned attorneys, responds to the respondent's multiple concurrent filing motions to reopen. DHS, out of abundance of caution, has no objection to the cases of her child being remanded so that Ms. may present an asylum claim, but does not agree nor stipulate that ineffective assistance of counsel have occurred.
So you want to go directly to the motion to reopen here?
Yes, Your Honor. So may I then jump to the ineffective assistance of counsel, the Lozada? We met all the requirements of Lozada.
Well, I'm not sure you've met them all.
Well, may I walk through them?
Well, sure, you can go
Sure.
through them.
So Lozada says you have to prevail on that. The respondent, Ms. has to write a declaration setting forth her relationship with her prior attorney, which she did. She has to give notice to the attorney, which she did. And she has to file a complaint with the bar, which she did.
The notice letter to the attorney was dated 1/18/24, and your motion was filed 1/22/24, which really didn't give the attorney any chance to respond.
Judge Smith, I appreciate that question. October 30, DBIA decided to deny Ms. motion, right? October 30.
Yeah.
By the time they found me was around November 20th. They already went to their attorneys, lost faith, said, okay, we better check another attorney. November 20th. I filed my petition, obviously within 30 days. We had a few days left. CAR arrives in my office on December 19. How else would I know? FOIA was filed, nothing on my desk. CIR arrived on December 19th. Holidays, Christmas, vacation. By the time I met with them was January 3rd. The petition to reopen is due by January 28th. I had 20 days to file 2 motions to reopen for him and her. There's no rule that says I have to give her enough time. I would love to have given her enough time, but you got to understand how on the ground it works.
Okay, so let's overlook that a little bit. What in the record says that has an independent claim? I looked through the record for an independent claim.
Yes,
only record that I have is that her claims are the same as her husband's.
Perfect. Thank you, Judge Smith. She has no claim. She's not even married to him. There is nothing for her. So the lawyer completely screwed up. She's not married to her husband. So she had nothing. The former lawyer showed up with nothing to the court. They're going to order her deported, death penalty to Honduras with nothing. Not a day in court. She's never been heard. So because she was not married, she had nothing.
I looked through the record to find out what would be the substance of her independent claim, if she had any.
Perfect.
And I could not find any.
If I may, let me tell you this. She has her own claim because she was a victim.
What in this record?
It is in this record because
Where?
I made it in this record. It's part of my motion to reopen, Your Honor, for Aditha with the BIA. She's a victim of a domestic violence. 3-4 times beating a week by a stepfather that made her mom strip naked and be beaten in front of the kids. Domestic violence is a ground for persecution, number 1. Number 2, her stepfather killed 18 member. They were pursuing them. So she had her own independent claim. It was never asked. Former counsel never asked her. That's all she had to do.
So let's talk about your past treatment claim. If I look at the past treatment claim, again, I have to give a lot of discretion, don't I, to the BIA and their decision in that decision-making process?
Yes, they have.
Okay, so I have here that there on October 2020, he was threatened by if he said anything to the police. Shortly thereafter, he sent a letter to, while he was gone, he sent it to the siblings of that time. And then in June 2021, he pulled a gun and threatened to kill him if he spoke to the police. Now, the BIA says, well, this is bad. There's no question, but he was never harmed. The threats were vague, not menacing, didn't suffer any harm. They were over an 8-month period. He was gone during some of that time, and there was no follow-through. And so therefore, not enough for past persecution. Now, given my standard of review, which is extremely deferential, don't I have to uphold this decision?
No, you don't, Your Honor. Well, we have who murdered somebody else. He
Yes.
testified to the police that he saw,
Yeah.
although the judge says otherwise.
I gave you that.
And then the police did nothing. He ran away, came back in 8 months. is free. He just told the police a man shot somebody and committed a murder.
Is there anything in this record which would give some credit to what the BIA said?
The BIA said nothing, as you know, Judge Smith. They just relied on the IJ, and the IJ said, I don't believe you told the police about very conveniently.
Did they say anything about the country conditions?
Judge said that it's under control and so on, and that is, in fact, Honduras is the most homicide in any country outside of a war zone.
So what do I do with these cases that say, even when the country condition evidence is contradictory or ambiguous, the decision maker can decide what evidence to believe and what not to believe?
I would tell you that being afraid for your life is sufficient persecution. Somebody doesn't have to shoot you. Somebody doesn't have to always follow you. It's enough to know that you are threatened by a gun by someone who you just witnessed committed a murder. I believe this is sufficient past persecution.
That's a great argument.
And that was my position on that. That past persecution has been established by mere virtue of him being threatened by a criminal who the authority let loose. I just have one thing to say. Futile to remand. Really? To protect a family? Death sentence. It's not futile. Far from it, Your Honors. Give a chance. That's all I ask. Reopen this case because we showed how the government is unwilling and unable to control this Mara. They killed twice at the same location, same car wash. First shooting, second shooting. Three people the second time. That's all I got to say, Your Honor. It's not futile. This has to go back. Thank you.
Thank you, Mr. Ballou. Thanks to both counsel again for your arguments today, and the case is submitted.